to reserve for rebuttal.
Of course, thank you.
Morning, Judge Case. May it please the court, counsel. Your Honors, my name is Charles Samarcus from law firm of Johnson, Pope, Boca, Rupel, and Burns. I represent the appellants Leopold B.O. Friedman and the entities that he controls. And we have filed this petition for writ of certiorari. Just by way of brief background of the critical facts, Your Honor, Mr. Friedman and his entities has purchased 5 nursing home properties in the state of Florida and the operating businesses that were on those. And those were purchased by an asset purchase agreement for the assets and an operating transfer agreement. Those operating transfer agreements transferred control and operations prior to the closing to the Friedman entities, as I'll refer to them. And then the transaction closed on June 27 of 2018. The essential asset purchase requirements were that the Friedman entities were paying off $58 million in existing debt, and also were going to pay over accounts receivables that existed at the time of the transfer purchases. Thereafter, after the closing, the Friedman entities and Mr. Friedman did obtain a loan for $58,000, paid off the existing debt that occurred, that was existing on the properties, and then continued to operate. Shortly thereafter, a time after, a disagreement arose, and that ended in this lawsuit where essentially the plaintiffs in the underlying action alleged that the Friedman entities did not pay sufficient amounts on the accounts receivable, filed a multi-count complaint. The count that brings us in here is a rescission count, and that happens to be count 2. They sued for breach of contract, they sued for breach of the asset purchase agreement, they sued for breach of the operating transfer agreements. But what's critical, Your Honors, and this goes to sort of what the essence of why the bond and why the lack of good cause exists, in looking at the complaint, essentially the rescission count alleges that the buyers did not pay the accounts receivable. And in paragraph 53...
It's a rescission based on fraud, not in the inducement of the contract, but on acts that didn't happen after the contract. Go ahead.
Yes, because the act that did not happen is the alleged payment of the accounts receivable. And in their complaint, they even allege buyers have continuously failed to remit sellers the outstanding accounts receivable. Therefore, there's no adequate remedy law other than rescission. And later they say, as a result of buyer's failure to perform its obligations, that's in paragraph 54 under the agreement, the contract between the parties should be rescinded. What then took us into court for this action is that the lawsuit was filed February of 2020. List pendants were filed in November and December of 2020. October of 2021, the motion to dissolve is filed. There's then a hearing that takes place in 2022. And at that time, because of the existence of the list pendants and the evidence that was introduced, is that Mr. Friedman could not, because of the existence of the list pendants, could not refinance the property. And so what he ended up having to do was had to negotiate an agreement with the existing lender, the Monticello, and the Monticello representative testified, and he had to pay an additional $600,000 to maintain.
So we're going through a lot of the facts of the case. The case is ongoing.
Yes.
It's certiorari.
Yes.
Why is there a departure from the central premise law?
Because there's 2 issues, Your Honor, that we're going to address. The first is good cause. And in looking at the court, in this court's case in Florida West Partners versus MTG, in order to have a list pendants that's not on a duly recorded instrument exist after the year has lapsed under 4823, there has to be the existence of good cause. And the lower court, Judge Muscarella, specifically in her order said, and she cited this court in paragraph 10 of her order, has reasoned that 4823 requires more than a fair nexus. The statute specifically...
So the fair nexus got you the list pendants, got the list pendants.
And the good cause, Your Honor, that is supposed to exist under this court's ruling has to do with the time and what happens.
So you're saying that you're not saying, I mean, I'm being rhetorical. You're not saying that the nexus went away. There's still a nexus. If there was a nexus, it still exists.
Yes.
So what is this more? So if we expand it merely from an assessment of very simplistic assessment of, is the case ongoing? In other words, has there been a final judgment entered? And beyond that, to whether the party prosecuting the case or, or the proponent of those pendants is, diligently prosecuting it's part of the litigation. What is the more? What is the more, logically speaking, that is required under the statute for extension beyond the 1 year?
The good cause requirement.
What is good cause?
Good cause is the prosecution of the case that it would allow it to extend beyond a year. Are you taking discovery? Are you setting the case?
Right, so the trial court, you're saying just because the trial court didn't go on and on about, and its verbiage about, giving indicia that was deeply contemplated, that somehow that's certiorari worthy because why? Because it wasn't being diligently prosecuted?
Yes, because it can't be corrected at the end of the case. If there was.
I'm not talking about jurisdiction, I'm talking about the departure of the essential requirements of the law.
Because the court has to find, this court said there has to be good cause and there has to be a finding of good cause to extend the list pendants in excess of a year, because the legislature said you get 1 year, because it's not a.
Certiorari, you have to establish that the court applied the wrong law.
It did.
Not that it applied the right law in a way that you think was inadequate, which we may even agree about, right? But that's not certiorari.
It didn't apply the right law, because what it did was to say the fair nexus is sufficient. In paragraph 12 of the order, it said, the court said in 11, the court agrees if the list pendants were released, the money goes and there's no adequate remedy of law. There's a lot of risk with the list pendants. The amount of risk is sufficient in itself to constitute good cause. That's not what this court said. This court says you have to look at all the efforts made. So it didn't apply the law. It didn't apply what existed, and it didn't use good cause.
If we were to quash the order, and say, look, you said the wrong thing, Judge. We can't be confident that you actually contemplated whether the litigation was being prosecuted diligently. Therefore, we conclude that there was a departure from the central requirements of law because you applied the wrong standard. And then the court does what? It goes back and says, well, yeah, it was being diligently prosecuted. Is that what could happen?
No, well, yes and no. I guess that's a possibility. The court could say it was not being diligently prosecuted. I didn't look at that factor. I just looked at whether or not.
Let's talk for a minute about, you tell me whether it matters on cert, whether we can look at the record and see whether it was being diligently prosecuted in a scenario in which, as you said, the court didn't ignore the correct standard.
I think it does matter. I think the court can look at it.
Okay, so why did this, give me some case law about why the prosecution of this case fell below that standard for good cause, as it relates to the diligent
There was no setting of
prosecution of the action.
There was no setting of depositions. There was no setting of the motion to dismiss on the counterclaim. There was no effort to set the case for trial. It sat there because it was acting as an impediment in order for Mr.
But what cases, are there any cases you have, I'm hearing you, are there any cases you have that you could analogize to say, well, in this case, there was no good cause because of these dilatory practices, and how does the alleged dilatory prosecution of this case compare to those cases?
Yes, Your Honor. Well, the Florida West case was the one, and the other one, I think it's JTL. Let me see if I can. JD. What they said in that case, it was another case, Your Honor, and I'll look at the citation, but I know essentially what they said was there was an effort to conduct discovery. There was an effort to oppose a motion for summary judgment, and the court found that was good cause sufficient to reverse the list pendants being removed. So I'll look in the one.
No, I mean, we have your briefs, I'm just saying.
It's in there, Your Honor. The court.
So I wanted you to.
It was the opposite, though, Your Honor. I don't mean to interrupt Your Honor. It was the opposite. Then the lower court said that there was not good cause. The appellate court said there is good cause by the prosecution that existed. So yes, there is a case that does that. It's just applying the opposite.
Your comparator is saying this is not that.
Absolutely. Absolutely. And the existence of the fact that, and we put in there, we filed for a motion for summary judgment, and the court and the order said, and I argued this last December, a judge said they haven't finished discovery yet, so I'm going to deny it as being premature. So there is no diligent prosecution. They haven't taken a deposition. They certainly hadn't taken it at this time. And why this is critical, Your Honor, this is not on a duly recorded instrument. So the court says, this legislature says, if you're going to go beyond a year, you need to have good cause to show what you're doing, not that it just sits there And in this case, it's even worse, Your Honor, because they didn't move to extend it prior to the expiration. This was time later. We said they haven't done anything. The look back was that there was nothing that happened here. And just pointing out there's
You're not arguing that's categorically disallowed. You're just saying that that's a factor.
I'm saying that's a factor, and it's sufficient evidence to demonstrate the contrary of the prosecution, demonstrating good cause for the purpose of the extension.
Let me ask you this. I'm having a hard time wrapping my arms around that this is a failure of the trial court to follow the essential requirements of the law for certain. And so I'm looking at paragraph 11, which seems here that the court knew that there was a good cause element. It says, in providing good cause, counsel for plaintiffs have argued, and this court agrees, that if the list pendants were ever released, the money goes and there's a lot of risk associated with list pendants. And before that, sorry, I meant to hone in on paragraph 10. However, Florida's Second District Court of Appeal has reasoned that Florida Statute 48.23 sub 2 requires more than a fair nexus. The statute specifically imposes a good cause requirement. And so, I think this goes to what Judge Atkinson was pointing out in the beginning, that if the trial court followed the law and did it wrong, then you don't meet that the trial court failed to follow the essential requirements of the law because the trial court just simply got it wrong. I mean, doesn't that really fit here to the order?
No, Your Honor, because she didn't follow the law.
Well,
so she didn't follow, you can't say.
She knew the law and said, this is the requirement, this is what the second DCA says. Now, mind you, she may not have got it right. That's what we're here to discuss. But my question is, do we even get to that point? Because it looks like this is the law that was laid out in the order and what she followed.
And my answer is no, because that is not the law. That you can cite whatever you want. She just went to the next line and said, there's a fair nexus. Why address the issue of if there's good cause? The requirement for good cause is to follow the law. It wasn't following the law, it wasn't misapplying, it didn't use the law. She did not use it. She just said a fair nexus, and that the fair nexus is, I'm trying to rescind an agreement, and if you sell that property, then that's going to impose.
Could it be the case that, okay, you're saying that fair nexus that existed when the list pendants was imposed in the first place cannot be the same?
Yes, Your Honor, because it has to be good cause to extend after a year. That is the statutory requirement. So it takes it away from just the fair nexus and say, look, under the law, you have to have good cause to go beyond a year. What is that good? Not misapplying it, but just not ignoring it. The good cause specifically by this court's own ruling in Florida West says you need to show diligence in prosecuting the matter. It can't sit here because it's not a duly recorded instrument. There's no notice. It doesn't go on forever.
Can you address the bond issue?
Yes.
I don't want you to run out of time.
Well, I'm going to, but that's okay. I'll try to talk fast. On the issue of the bond, and certainly on the damages, I understand that, I don't want to belabor the $34 million, but the $600,000 fee, the bank has said, look, you've got to list pendants. You need to pay $600,000 if you're going to continue this. That is a minimum amount that certainly Mr. Friedman and the entities have suffered. There was $67,000 that came in because of the list pendants, and there was testimony about that. The title insurance, they couldn't use the same title insurance now. They said you need to put up another $500,000.
So there's roughly about $1 million, I think, apart from the $34 million. Okay, so let's talk about the $1 million. I think there's some argument here that there wasn't preserved below.
I don't know what the argument was. The testimony from the banker was, Mr. Friedman had to list pendants. We didn't have to extend automatically. We told him to pay another $600,000. The $500,000, I think they're saying, is some sort of escrow, but the title insurance company required it. My client pays it out. If he doesn't get it back, how does that come into play?
Does it matter at all that, as Appelli would argue, and that they'll make a better argument than I'm going to make right now, but that the trial court wanted to continue the hearing and take more evidence, and then that didn't happen because they jumped the gun.
No, Judge, it doesn't matter because it existed. Could have been ruled on there and said, look, I've got a problem with the $34 million, but you're going to do it for one. And that wasn't happening. It's not jumping the gun to go back.
In other words, they didn't say, hey, well, they didn't come back and say, well, here's our evidence for the $34 million where beef that up a little bit, but you could also just, you know, go for the 1 million, judge, if you reject this. Instead, they said, we want the whole enchilada, and we think you're wrong, and we're not gonna, you know, you want to continue the hearing, we're done, we put up enough, and we want you to reconsider your ruling.
She entered an order denying any bond, Judge. That's denying that. I'm sorry, that's my 15-minute. May I finish the answer to
Yeah,
this?
you can finish, and I'll still give you your 5 minutes, if you want to answer my question.
Your Honor, by doing that and denying any existence of the bond, she didn't put in the order. I find that there's 600,000, I find there's 500,000. I don't find this, I'm not going to enter. It was a final order, so it was an order saying there is no bond going to be a requirement. And frankly, the fact that that was done is demonstrating that there is no bond that's been put up. It's not jumping the gun to go back. It wasn't happening. It's not an order that says it. So it's not waived by coming in and saying, we want to have this addressed. We believe, and the evidence shows that those were certainly damages that should have been put, or potential damages at least, that should have been put into a bond, even for that amount of money, versus just saying, I'm not going to put up a bond. So,
Full 5 minutes.
pardon me, Your
With
Honor?
your full 5 minutes, I might give them a little extra time.
I missed.
No, so you'll have your full 5 minutes, I might give the police a little time to.
Okay.
For what I gave you, thanks.
Good morning, Your Honors, and may it please the court. I'm Kevin Marino, Tortorella, and Boyle for the plaintiffs in this case and the respondents. Your Honors, the judge did follow the essential requirements of the law. The petitioner does not like the result, but that's not certiorari. Certiorari, as Your Honors have made clear in your questioning, and as the cases themselves make abundantly clear, only obtains in a circumstance in which the trial court failed to follow the essential requirements of the law. Judge Smith.
Should we infer from paragraph 11, when the trial court said, in providing good cause, counsel for plaintiffs have argued that this court agrees that if the list pendant, and this court agrees that if the list pendants were ever released, the money goes and there's no adequate remedy, there's a lot of risk associated with the list pendants. Can we infer from that the court presume that good cause could be satisfied by merely repeating the grounds that established the nexus to begin with?
I think good cause can be established by repeating the grounds that were asserted at the
Let's say we
time.
take a contrary view under, what's the case again?
It's Florida West.
Yeah.
And what Florida West says is, it's not enough to just have the fair nexus. You also have to have good cause. But let's examine that for a moment. All that the placer of a lis pendens, the plaintiff in this case, needs to establish is that there is a connection between the properties at issue and the litigation. That's what gets you a lis pendens, fair nexus. That at that time, it was also clear, and remains clear to this day, that there would be very significant harm that would attend for example, the sale of the property, the encumbrance of the property, that existed at the time that the lis pendens was first put in place, doesn't mean it doesn't constitute good cause. It's not as a, well, not only did you have enough at the time you placed the lis pendens to say, yeah, it's connected, you also, it was very obvious that, man, we're going to need a lis pendens here for the duration of the case, because if we don't have it, all these risks that the judge so clearly set forth at paragraph 11 would continue to obtain.
That's a fair reading, I guess, of the statute with regard to how to extend it beyond a year. But don't we have case law that suggests another reading, which is that because that the statute contemplates this additional showing, it must be something different than the initial nexus and the initial cause?
I think the cases, first of all, I think it's a little overstated, right? I think what happened in Florida West, remember, in that case, the court, and this is, it's an abuse of discretion standard, right? So in that case, in Florida West, what the court said is, all right, certainly there has to be something beyond just a nexus. So you couldn't just get up after a year and say, well, this property is connected to this litigation. That would have been enough to get you the lis pendens in the first place, because that's all that matters. You're giving notice to the potential buyers, you're not going to encumber the property, and so forth and so on. that would have been enough. But it's not the case that because you also have to have good cause, it's not the case that for some reason, if you had all this good cause at the beginning, now you have to have more good cause. And this idea of diligent pursuit, how does that arise? It arises because in Florida West, what the trial court said was, well, there was nothing done here to show good cause. That's what
You're
they're
saying you have a
saying.
nexus and good cause to begin with.
And does a good cause evaporate because a year goes by? No.
Well, I think that the case says, nevertheless, fair nexus does not necessarily equate to good cause. I think that's where the argument is coming from. So you would agree with that, right?
100%, and so did the trial court agree with that, and made it very clear at paragraph 10, as Your Honor indicated earlier today. Florida's Second District Court of Appeal has reasoned that statute 4823-2 requires more than a fair nexus. The statute specifically imposes a good cause requirement. So that's the judge applying the law as written, right?
It's, well, I guess one would argue as opposing counsel has that while recognizing it doesn't necessarily mean that it is applied. And the argument being made that the paragraph following alludes to the fair nexus. So obviously that's why we're here.
Okay, but actually the following paragraph, which is paragraph 11, says, in providing good cause, counsel for plaintiffs have argued, and this court agrees, that if the list pendants were ever released, the money goes and there's no adequate remedy. There's a lot of risk associated with the list pendants. That would be good cause by anyone's lights. And let's remember what good cause is. There's been some confusion around it. State versus Boyd is the case in which it's defined. And in Florida West picks up on State versus Boyd and says, what is good cause? A substantial reason, a legal excuse, a cause that was not arbitrary or contrary to all the evidence. That is the good cause standard, right? And the Boyd court, which Florida West relied on, said the determination of good cause is based on the peculiar facts and circumstances of each case. The trial court is in the best position to weigh the equities involved, and its exercise of discretion will be overruled only upon a showing of abuse. How could it be abusive for the trial court to say there's a lot of risk here? If this list pendants goes away before the end of the case, all the kind of problems that the list pendants exists to prevent would come home to roost. That's the essence of what the judge says. That's why, frankly, I don't think this is a certiorari case at all for that reason, right? I think that from a jurisdictional perspective, you don't come to the appellate court during the pendency of the case, and now we've had plenty of discovery. We've had hundreds of thousands of documents that have been exchanged and a protracted dispute over conflict and so forth. You don't come before the appellate court and say, hold it. There's been a departure from the essential elements of the law. No, there hasn't been. There has been an application of the law, and here's the application. The courts, the Florida courts have said, you don't just have to have a fair nexus, you also have to have good cause. And what is a fair?
Assuming there's good cause for the entry, the trial court detailed in its order, I think on the bond, after the bond hearing, in paragraph 5, and talked about the evidence that came in on the damages. The $600,000 for the extension of the Monticello loan, $500,000 in escrow for the title insurance, and then the $67,000 for the construction cost. $34,000 I'm going to kind of leave out here, but for now, because the trial court made that additional finding later on that it couldn't get to a total amount. So as far as the, what was it, like $1.3 million or something like that, that amount, why was that not competent substantial evidence for the bond?
Well, because what transpired, and you have to be focused on procedurally how this arose, right? So they make a claim, they want a bond of $35,170,000, right? And the court says $34 million of that is speculative. it's based on an interest rate that was obtained at this time, no suggestion here as to what the rates would be or whether there could be a refinance or anything else, all very speculative, right? So put that aside, talk to me about asking for a bond. You're entitled to it, right? If you have these damages, you're entitled to a bond. They made a strategic decision to say no, to flout the court's directive and say, here's what we want. Will give us an interim bond, which doesn't exist. What does that mean? That's something they made out of whole cloth. But let's give us an interim bond, and then and of course let us continue to argue for the other 34 million, or just reconsider. And please, we'd rather go to court right now. We'd rather have you enter an order rejecting us completely. They made a strategic decision not to request the bond. So again, how did the trial court fail to honor the requirements of the law? She totally honored the requirements of the law to a punctilio. She said the $34 million is too much. You certainly should get protection as the list pendants goes forward on the hard losses that you've described, the 600 and the 500 and so forth. So there's your $1.1 million. Come back in and ask for a bond. They said, no, thanks. We'd rather have you say no and let us go up to an appellate court and make the argument that you departed from the essential requirements of the law by not by not giving us a bond, which she was perfectly prepared to do and had 2 hearings on the subject, but by not giving us the bond we want, which is $35 million. That's what they were looking for. They did that. So what is this court to do? Is this court to correct that? Is this court to say, wait a second, you made a mistake there. That was a poor tactical choice. Let us help you fix that? I don't think so. That's what they should have done. You listen to the judge. When the judge tells you what's going on, that's what the robes are there for. The judge tells you to do it, you do it. They come back in on reconsideration. They had 2 hearings. The first hearing said, look, you have to be quite specific about these losses. This $34 million is a problem. Let's put it to one side. Let's talk about your other $1.1 million. Well, that was their time to come back in and say, we understand, Your Honor, please give us a bond in this amount. They didn't want to do it because they perceived this not as a certiorari court in the way the law speaks, right?
What was supposed to happen at the continued hearing that never took place?
They were supposed to put in evidence as to, not only put in evidence as to, to make the hard bond request, right, to support the request, but to actually say to the judge, please give us a bond in this amount. Instead, they said, you know what, give us reconsideration.
But and they obviously were swinging for the fences, as lawyers do. But you don't always get the home run, you get a base hit. But why just because there was the trial court? What I asked is what was supposed to happen that didn't happen? And then why does that foreclose the trial court saying, you know what, I'm just, like I said before, I don't buy the $34 million. And what foreclosed the trial court from just entering it based on the insurance cost, the out-of-pocket guarantee, I forget what that was, the $600,000 guarantee or whatever. What prevented the court from just entering it for a lower amount?
Sua sponte? Because that's what that would have
sponte
been.
if that evidence was
I think it
presented.
would have been sua sponte because they were supposed to come in. See, the fight was never about the $1.7 million, $1.1 million, I beg your pardon. That was never what it's about. The fight was always about the $35 million, the swinging for the fences. And they were very strong on it. It's obvious that the $1.1 million was not significant to them. Obviously not significant to Leopold Friedman. What he wanted was the $35 million. So what the judge says, come back in and show me where the $35 million comes from. They didn't do that.
Well, no, I think, wasn't it about the 34? Because
34 million,
you already
sorry.
made findings
Yeah.
about the other.
Yes, that's right.
Okay, so are you saying that they said, don't give me, that they waived the 1 million
Yeah.
by asking for the 35?
Yes,
Is that your argument?
Yeah, and they did. In fact, they expressly waived it. They said, give us an interim bond in that amount. So, I mean,
Let me go back to the findings of it. You would agree that in the beginning, that the trial court found that there was a sufficient basis for a bond?
should get 100%, yes, absolutely.
Okay.
Absolutely. So there's a sufficient basis for a bond, and the trial court wants to set the right bond, right? The trial court sees that there's $1 million.
It's $1 million in evidence and agrees at $1 million at least, but can't get to the 34,000 claim.
34 million.
34 million dollar claim.
Right, and that's what the court says. But at that point, had they come back and said, all right, here's what we can establish. Here's the 34 million, what makes it, more significant, what she was asking for in the second hearing, to go along with the $1 million. Please enter a bond. The court at that point could have said, okay, I don't find this amount sufficient, but I'm going to put this bond in place for $1.1 million. She certainly could have made them post a bond of $1.1 million. The reason the court didn't do that is because of the manner in which they proceeded. They didn't want a ruling. Let's be clear, and I'm sure counsel will not dispute this. They didn't want a ruling on this 1.1 million. They wanted the judge to either give them the 35 or let them come here and ask you to give them the 35. And that's what's here. The question here isn't whether they're entitled to a bond, because the judge, again, to a punctilio, followed the requirements of the law. She found that a bond was appropriate, and she found that what they had established was $1.7 million. They came back and said, no, we're going for the gusto. We're swinging for the fences. And please, either give us an interim bond.
Wait, where did the court in the record say that she would give a bond of the 1 million?
She said a bond was appropriate. She said the bond was appropriate. So implicitly, Your Honor, she said a bond it's appropriate for there to be a bond. But my problem is with the 34 million.
Let me ask this, if a trial court considers that the evidence is adequate or supports a bond, could it, based on the language in 4823, that the court may impose? Oh, and wait, maybe does that may apply to the bond amount? In other words,
Yes.
does a trial court have the discretion not to enter a bond, even if the party seeking the bond has established the bond, that there's evidence that there would be risk that the bond would cover?
I don't believe so. I don't believe so, Your Honor. I think that what should have happened here, from my perspective, is they should have come in and said, we can't, well, here's our presentation, right? Set the bond as Your Honor believes that the evidence supports. Instead, they came in and said, give us the interim and either do that and reconsider, or just please deny, rule against us. I mean, that's the bottom line. I mean, look, there's a reason for them to swing for the fences beyond the fact that there's a difference between $1.1 million and 35. And that difference is, look, if we have a bond in place that the plaintiff can't meet, then we're going to get this lis pendens lifted. He knows very well that Joseph Schwartz could meet $1.1 million bond. He didn't want $1.1 million bond. So again, like, I completely agree with the court. There is no doubt that the evidence was there to establish a bond in $1.1 million. The question presented for this court on certiorari, though, isn't did the judge abuse her discretion by not setting the bond at $1.1 million? That wasn't requested ever. And in fact, they went out of their way to say, don't please rule against us. Because let's think about strategically why that would be done that way. Because now we can come up to the court immediately on certiorari, and we're swinging for the 35.
Well, let's talk about, I think I can take your point. I don't know if my colleagues want to hear more about that, but I want to, at least in time remaining, talk about the 34. There's been competing claims of speculative argumentation about the 34, but on your client's side, isn't the speculation that they could definitely somehow refinance? I mean, it's the point, I understand the argument being made by your client, which is it's speculative. You might not even keep the property. How do you know you're going to pay all this interest over however many year loan you have. But isn't there a competing claim of speculation, which is your argument against the 34 million is that, well, you can't claim all this future interest because you can only claim costs during the time of the pendency of those pendants. I'm not sure that makes sense because let's say that it could be conclusively established that you're locked in. You've got this loan, you can't get out of it. You're presuming that they can be refinanced at some point for a lower rate.
The difference is burden. Who has the burden of proof? I don't have the burden when they are looking for a bond. They have the burden. And what did they have to come in and show? They had to come in and show losses that were not compensable. So what is the standard? The standard is, first of all, they got to show that there was a kind of harm, right? Kind of harm that could not be recompensed with money. That does not exist. The 34 million being speculative is one piece of the story, right? And obviously, when they say 34 million, wait a second. If you didn't put this list pendants in place, we could have gotten a HUD loan for 2.85. Now we're stuck with 5.2. That's what's accurate today. So take that, go out 35 years, ignore whether we could have gotten some other loan, ignore whether we could have gotten it refinanced, and just say, here's the number, it's 35 million. It's just that the effort there is to make the number as big as it possibly can be.
I guess my point is, yeah, I understand the argument you're making about how there's some speculation that you're going to stay in the property, that you're not going to refinance. But the idea that there's some categorical, prohibition on looking into the future with regard to a bond evaluation.
I don't love that argument either.
If it could be proven that there's no way we could ever refinance, then the delta between what you got and what the lower rate you could have gotten is what it is, and throughout the course of the loan, that's what your damage is.
I would agree with that completely. I would say this, Your Honor. If you had hard evidence, right, not speculative, okay, we need to be protected at the end of the day. Because if we win, and look, they are very confident they're going to win, we're very confident they're going to win, welcome to litigation, right? But if we win, here's what we are going to suffer in real losses that can't be compensated with dollars. Why couldn't it be compensated, whatever dollar figure they arrived at? Why couldn't that be compensated with money? How is that irreparable harm? It's not. That's number one. Number two, they haven't even made taken the opportunity. The judge gave them the opportunity. Okay, come back in and show me the proofs that say, here's the 34 million piece. I get the 1.1, show me the 34. And they came back in with the same thing because they don't have anything beyond that. So, yeah, there's speculation going in both directions, but they're the ones looking for the bond. Why are they the ones looking for the bond? They're the ones looking for the bond because we put a list of pendants in place because there was undoubtedly a fair nexus between these two things, and there is undoubtedly good cause, as the judge specifically said. So for all of those reasons, this is not a certiorari case, and it's certainly not this court's job to go back and set the bond amount. They had the opportunity to say, you know what, Judge, here's our shot, and then she would have made the call at the end of the day. But they didn't do that. That was a strategic choice they made, and they're hoist on their own petard as a result. Thank you, Your Honors.
You have your full 5 minutes.
Thank you, Your Honor. I want to start with, first of all, I don't want there to be any mistake. The court order said the request to set a bond is denied. It didn't say $1 million. It didn't say you waived because of it. And as for Mr. Schwartz having my client saying he could put up $1 million, he had been under criminal indictment. He has subsequently pled guilty and is facing jail. My client has no assertion that he put up $1 million, $1,000, or $35 million. There's nowhere in the record that says my client's looking for more money. The court had an opportunity. How many times does my client have to go present the same evidence? It exists.
Let me ask you this, on certiorari for departure from the essential requirements of the law. I know that a bond, jurisdictionally, there's cases that say that it's irreparable harm and unable to be recompensed after appeal. So we get past that. But how do we assess the departure issue here? When it's a discretionary matter that in the statute says the court may impose a bond, how's it a departure, even if we concede that the trial court perceived there to be competent substantial evidence that would have supported a bond, that the trial court departed from the essential requirements of the law by not imposing one?
Because it's essentially, Judge, an injunction without a bond. It's essentially saying, we're going to allow you not to have the full ability to use your property without putting up a bond for something you have a legitimate damage for. And Your Honor, one of the other case pointed out, the avenue that you have is the bond. That is the protection that's put in place for the defendant. That's why that's a departure from the essential requirements of the law, because that protection is put in place to have the bond so that if the lis pendens was wrongfully recorded, there is an avenue there that's recognized with evidence by the court saying, I find that this is sufficient to put up the bond. The other issue, Judge, and I went and looked, it's the JBJ case. When we're talking about good cause, this whole issue about the nexus, that's why this court said in Florida West, and I want to quote you, that you said there has to be, the statute requires more, even if there's a fair nexus. And what the issue for good cause, Your Honor, in that JBJ case, the court said that this court failed to make findings relating to the good cause and instead issued an unelaborated.
Good cause and you have nexus. Let's say that those are actually two separate things. You might be wanting to argue that they're the same thing and you need more, but if here's your good cause, there's a nexus, meaning here's the bad that could happen if you don't put the lis pendens on its property, it could be sold or whatever. And then good cause means something different.
Yes.
At the time of extending the duration.
Judge, absolutely. That is absolutely what it says, and I'm quoting, because what the court said is that we define good cause in Goldman, finding that it is and I'm going to quote, a substantial reason, one that affords a legal excuse or a cause moving the court to its conclusion. Good cause relates to moving the case forward. That's why I looked up the JBJ case. What the court said in that is that it's undisputed petitioner has actively litigated the underlying case and sought a timely resolution. The court went on to say, the appellate court in that case, it has propounded and responded to numerous discovery requests. It moved for summary judgment. It noticed its motion for hearing. It opposed a motion for continuance on the summary judgment. It's the activity that takes place for the case to show you're moving the case that's good cause. This whole argument about the nexus, that's why the court never considered good cause, never even looked at it. It cited this court's decision. But when if this court looks at its own language, it's how is this case moving? And by the way, that's why this court in Florida West said, we cannot say that the trial court erred. During the 14 months that the lis pendens was in place, Florida West, with insufficient explanation, did nothing to move its case along. It provided no good cause for an extension. That's this court's case. The good cause solely, Your Honor.
There's no record action in 14.
Nothing they put in at the evidence for hearing to say, here's why we need good cause.
Was there no record action for 14 months? Not record action, but I mean action, you know.
Judge, I don't believe so, but I was not counsel of record then. I came onto the case. I didn't review the docket, so I don't want to ask. I can only tell you what we argued, my co-counsel that prepared it, okay? So I don't want to misrepresent to the court, but I will tell you this. They haven't taken a deposition, and we're supposed to go to trial in 3 weeks. So in terms of if we're looking at good cause and how...
I don't want what's in the record before the court.
I don't believe, Judge, but to be candid, I don't want to misrepresent. The transcript is there, and I would have to defer to the transcript. So I just don't want there to be any misunderstanding that the 1.1 million is not something that my client was saying, I don't care about, I don't want to do. The court orders that we're appealing say, we deny the bond. It says the court denies the bond. And so we're asking for reversal. If you ask for relief, the court can put the relief that it finds and reject the rest. It didn't do that. It rejected all of it, including the $600,000, the $500,000, and the construction cost. So we would ask that for the reasons outlined that the court grant the petition. Thank you.
Thank you.
Thank you.
And that concludes our argument for the day.
All rise.